Welcome back to this final segment of the law session on contract, dealing with how you approach answering exam questions in contract law. Now, we have already considered, first of all, a general approach, and we have managed to look at a contract formation question, and we have also managed to look at a misrepresentation question and how you would answer them. What we are going to consider in this final segment, of course, is a question on mistake. And in particular, we are looking at an essay question. For this, of course, we return to the University of London's past exam papers. And this time, we will look at question 6 from 2010, which was a question on mistake. And in particular, it was an essay question. Now, as I said, a word about essay questions is that I would, of course, refer you back to the first segment of this law session, simply because in that I flagged up for you how you should approach an essay question. You really should consider what is it that the question is asking me, and then you focus on that particular question, not a mistake question, but that particular question asked. All right. The question read, English courts are reluctant to render a contract void for mistake. This has meant the construction of a very restrictive doctrine of mistake, which has, in turn, rarely been applied to vitiate an apparent contract. Discuss. Now, there are certain words in contract law that you really need to be able to have a handle on. Things like vitiate, you should know what it means. Things like repudiate, you should know what it means. These are terms of art when we look at contract law. So when you look at vitiating, for example, when you talk about vitiating factors which will, of course, allow you to repudiate or end the contract. So here it looks at a specific essay type question, which then asks you to discuss. Well, very good question if you had prepared for mistake. Again, the danger sometimes is that an apparently easy mistake question is avoided by students who feel they don't like writing essays. But if you just consider what the idea of the essay is, you will be just fine. Now, if you had prepared for mistake, fairly good question. The first thing, of course, is that this was not an invitation to write all you know about mistake. That tends to be one of the dangers with essay questions, is that person latch onto the area of law. So for example, it's about mistake, and then they go into the types of mistake and this type of mistake and unilateral mistake, and they pretty much give the examiner a summarized chapter 1 of mistake. This question was not an invitation to do that. You've got to ask, what is important? What is the question? How do you do that? Look at the words the examiner has used in this statement. Words like restrictive doctrine. Words like rarely been applied. Words like vitiate an apparent contract. So it doesn't matter what you know about a subject, you must then use that information to focus it on the question being asked. So if the question being asked is about restrictive doctrine really being applied, you use the information, but you keep using back the words as you write a paragraph. What did it mean in the context of the question asked? So in the answer, use the words raised by the examiner rather than just writing generally about mistake. These show focus on the question asked rather than giving the examiner just a general answer, which, go back to my Jeopardy analogy, you look at it, but you know the person is writing on mistake, but you would never pick up that it was something to do with vitiating or anything like that, because it doesn't say. So there are 2 points of focus. The first that the question looks at is that the doctrine of mistake is highly restrictive. And second, the mistake is very rarely found to apply in any given instance. Now, going back to that actual exam question, what the examiners who marked the paper when they saw the candidate script, one of the criticisms on that particular question was that while candidates should have considered some or all of the case law in order to address the topics, they said many students did not. They said that students produced a list describing various mistake cases, but what the student didn't do was to analyze the topic. Now, you're going to get questions which talk about analyze, discuss, critically evaluate. What does that mean? It means you're going to take the information you have in relation to mistake and use it to slant along the lines of the question to give an answer which, using the question which is asked, contextualize the information you know. So how do you analyze the topic? Well, look at the first statement. English courts are reluctant to render a contract void for mistake. Well, do you agree with that? It would seem, for answering purposes, I would want to possibly slant my answer towards favoring the statement because it would give me more substance. So, for example, you could start off by directly focusing on the words in the question asked and possibly respond by saying something like, the cases have certainly appeared to show a slant towards not finding that circumstances exist sufficiently for the finding of mistake to render a contract void. However, the cases have proved somewhat inconsistent, not least by the distinction of in person and in absentia in the conclusion of the contract. As such, given the vast majority of contracts are made face-to-face, and given the court's attitudes towards inter-presentes contracts, there is that rarity in finding that a contract will be vitiated on the basis of mistake, and, arguably, even the recent case of Housen Finance underscores the court's position that it will continue to support this distinction. What have I done? I have focused on the points made in the question, right? So from that base, you could then take the examiner through an analysis of the cases in relation to that area. But what you've done is started by focusing on the particular question asked about mistake rather than just answering a general question about mistake. So you would then take the examiner through an analysis of the cases. We know them: Conde and Lindsay, Ingram and Little, Lewis and Avery. But the point is not just to list the cases and give the examiner the facts, and then when you finish you say and therefore and put back the exam question. Don't just list the cases and give the examiner the facts. The examiner knows the facts and the cases. He wrote your exam paper, so God help you if he doesn't know the facts. He does. He knows them better than you do. And don't teach the examiner the law. When you analyze, you're doing a critical evaluation. You treat the examiner as a peer. You say to him, it is clear, you say things like, not for this question, but just as you're answering, you say things like, well, it is clear that when one considers the line of cases relating to a particular principle, for example, you can then say, a contrast must be drawn in relation to contrasting cases, and you give the line of cases. You don't just say, also. Whenever I see a law student put in the word also in an essay question, it makes me cringe because I'm always worried that we are in listing territory. Don't teach the examiner the law. Use the cases in a critical way to answer the particular essay question asked. So as you then come to the main case of Housen Finance for this question, you would want to then discuss possibly that this was maybe a missed opportunity for the court to place this area on a firm footing, and they failed to grasp the nettle, and as such, this restrictive doctrine, using back the examiner's words, has operated in a manner that its construction in relation to the cases has operated rather restrictively. You notice I keep using back the words he's given me. Remember that you should then conclude. Your conclusion is not a rehash of what you've already said. Your conclusion, again, here's a challenge for you. Try writing a conclusion without saying in conclusion. Try using something like in all the circumstances, or it is clear therefore, or given the substance of the discussion, or in light of the overwhelming arguments in favor of. But I should see that there's a conclusion without you having to say in conclusion, because a lot of times when students do that, it is because they've basically run out of stuff to write. So what they're doing is just saying in conclusion they come up against a wall, and then it's, oh, I have nothing else to write. Don't let that get you caught out. Show how the arguments you presented have answered the question, the specific question asked, rather than a general mistake question. Now, again, if you are signed up to our premium service, then I would ask you to contact us to request a copy of a sample answer to this question, which was, again, genuinely written by me under timed conditions of less than 35 minutes. That, of course, brings us to the end of how you would approach contract law exam questions, and certainly I hope that you will take this away with you and be able to implement. Equally, if you are on our premium service, then you will continue to get the support you need, and certainly I will be here to help you.